Is a failure to request a cross-racial ID charge and a failure to impeach ineffective assistance of counsel? To find out, you have to read People versus Lucas, but it's 9 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases and I try to do it in 5 minutes or less. This is the episode on the case of People versus Lucas. The citation for this case is 2024 New York Slip Opinion 02843, published by the New York Court of Appeals on May 23rd of 2024. The issue in this case is whether it's ineffective assistance of counsel, 2 different issues, for a failure of defense counsel to request a cross-racial identification charge and failure to impeach a prosecution witness with prior inconsistent testimony from a suppression hearing. To understand and appreciate the context of this case, I think the helpful background to know is that the Constitution has a 6th Amendment, which includes a right to counsel, which means a right to an effective assistance of counsel. So when people claim a failure to provide an effective assistance of counsel, they're really claiming a 6th Amendment violation. There's 2 different standards that are relevant to this particular case on what ineffective assistance of counsel constitutes. The federal standard and the New York standard. The federal standard is a 2-part test. It comes from a case called Strickland. And the 2-part test is, did the trial lawyer's conduct fall below an objective standard of reasonableness? And part 2, is there a reasonable probability that but for counsel's unprofessional conduct, the outcome of the proceeding would have been different? So the 2 parts are below objective standard of reasonableness, and did the failure affect the outcome of the proceeding? That's the federal standard, the Strickland standard. There's a New York standard from the case of Baldy from 1981, Court of Appeals, and that case says that standard is, does a review of the totality of the evidence, law, and circumstances of the particular case show meaningful representation? So the New York standard is meaningful representation. Okay. So what are the facts in this case? The facts are often the most complicated part of an ineffective assistance of counsel case. This is a little complicated. In June of 2016, a priest was heading to church in the morning for services, and he claims that as he was walking from his car to the church, a man approached him on the left side, pulled out a gun, and demanded his keys, wallet, and cell phone. He claims that a second man approached him from the right, sort of hemming him in. The priest handed the property to the gunman, who then punched him, knocking him down. The 2 men left in the priest's car. The priest, we're going to call him the victim from now on. The priest's victim's car, they drove away. The priest called 911, said it happened very fast, and that the assailants were 2 black African-American men. They pulled a gun on me. The incident was captured on video. The police got the video that same day. It showed the victim being approached from behind, and by the 2 different people, and it shows them standing on both sides of him before the victim fell down, and the 2 men drove off in the victim's car. It also showed them wearing hats. The surveillance video led the police to an abandoned house where the police found the defendant and his co-defendant, Kerry Pack, on the same day as the robbery. They were arrested. With them was found the victim's cell phone case and the 2 hats that appeared to match the hats worn by the robbers in the robbery. The same day, the priest victim picked the defendant out of a lineup. And this is important. Detective Morales testified at the suppression hearing later that the victim identified the defendant as the gunman, one of the guys that mugged me, and stated the defendant could have been the one with the gun, but he wasn't sure. That's what he said. The court conducted a suppression hearing on the lineup and found it was valid. The defendant and his co-defendant were charged in indictment with acting in concert to steal the priest victim's property and named Pack as the gunman. At the trial in 2017, now the trial is occurring, the people contend the victim had accurately identified the defendant as the gunman. On cross-examination, the defendant confronted Detective Morales with the felony complaint that named Pack as the gunman, and Morales testified that he simply made a mistake and got the names mixed up. Okay, that it really was the defendant, whose name is Lucas. Morales testified the victim told him it was the defendant who was the gunman, took the property, and punched him. The defense counsel at that point did not, and this becomes one of the bases for the appeal, did not impeach Morales with his inconsistent testimony from the suppression hearing that the victim wasn't too sure whether the defendant, in fact, had the gun. The defendant then testified in his own behalf here, and the defendant said, I was there. He puts himself there. He says that he was in the surveillance video. He said he had nothing to do with the robbery. He said he followed Pack in approaching the victim only to ask for a cigarette and change, and was surprised when Pack pulled out a gun, demanded property, took the victim's property, knocked the victim to the ground, and drove away. The defendant said he pulled Pack off with the victim and got in the car, but he denied ever hurting the victim, demanding property, possessing the gun, positioning his body to hem in the victim. At the charge conference, the defendant requests a one-witness ID charge because the defendant contests the victim's identification as the gunman. The judge gives a one-witness charge, but does not include the part that talks about cross-racial identification being sometimes less accurate, being one of the factors that can affect accuracy of identification. The court said that since race was not an issue during the trial, and because there was no expert, he was not going to give that part of the charge. The defense counsel agreed. So the court did not give the cross-racial ID charge. The defendant was convicted of Rob 1. He appeals. The appellate division affirms, finding the defendant received meaningful representation. That's the Baldy standard. And he appeals to the Court of Appeals. So here the two questions are: was the failure by defense counsel to impeach Detective Morales with the suppression hearing testimony ineffective assistance of counsel? Failing to identify him, talking about the identification as the defendant as a gunman. And the answer is not ineffective assistance of counsel. Why? It's significant, but it alone, without by itself, does not constitute ineffective assistance of counsel because there may have been a legitimate strategic reason to do so. Maybe counsel was trying not to call into credibility the sympathetic priest victim. Maybe counsel was trying to avoid reinforcing to the jury that the victim did in fact ID the defendant as the gunman at some point. So because there's alternate possibilities here, it's not as a matter of law ineffective assistance of counsel. And as to the cross-racial ID failure to insist upon getting it, was that ineffective assistance? No. Because at the time of the trial, it was not mandatory to do so. That was not a mandatory requirement, which now it is, but then it was not. And that's the case of People versus Lucas. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.